Okay, so since it's 5 minutes past the hour, we'll go ahead and get started. So I'd like to welcome you all to FSA's webinar on the introduction to tribal financial management. I'll start by introducing myself. My name is Jenna Williams. I'm a member of the Mandan, Hidatsa, and Arikara Nation. I've been with FSA since FSA's Tribal Administration Services team since April of 2022. Next, I'll introduce today's presenter, Justin Lepsher. So Justin joined FSA in July of 2021, and he is now the director of the Tribal Administration Services team. Justin is an enrolled member of the Menominee Indian Tribe of Wisconsin. He was born and raised on and near the Menominee Indian Reservation, and he received his Bachelor of Science degree in Business Administration with an emphasis in leadership and change from the McDonough School of Business at Georgetown University, and holds an MBA from the Schneider School of Business at St. Norbert College. Before joining FSA, Justin worked as a federal contractor at the National Institutes of Health, a senior grants and contracts specialist at the University of Wisconsin-Madison, and a data reporting specialist at Northeast Western Technical College, a mortgage lender at Bay Bank, and finance manager for the Menominee Indian Tribe of Wisconsin. Justin has also served as a member and chairman of the board of directors for the Wolf River Development Company, Menominee Tribal Enterprises Board of Directors, board member for the Wisconsin Trust Account Foundation, and currently serves on the College of the Menominee Nation of Board of Trustees. Woof, Justin, busy. And now I'll hand it off to Justin.
Thanks, Jenna. So we're excited to present today's topic of the introduction to tribal financial management, and looking forward to hearing more from folks if there are any questions and any feedback via email or comments after the presentation. So first, we're going to start out with the basics of tribal financial management, taking a look at the culture of tribal governance, as well as some history on tribal financial management and how we got to where we are as tribes currently. So as we take a look at a culture of tribal governance, the tribal nations overall have a unique responsibility in that they have to manage not only the governance and the people of the nation, but also the land and the culture. And so this is really what makes us different than local governments. The government structure is different. Our leaders have a different responsibility to protect the land and culture of the people, whereas local cities and mayors do not have that responsibility to preserve that culture and language. So as we take that into consideration, the way we govern and the types of decisions we make are around culture and other responsibilities. One example of this is my own tribe, in which our reservation is heavily forested, and we manage our forest using sustainable yield forestry here at Menominee. And what that means is that we do not go in and take the high value timber based on the value. It's based on how we can maintain our forest for multiple generations in the future. And due to our forestry practices, we have more standing timber now than we did 100 years ago. And so that's just a testament to the responsibility of our governance and our taking into consideration more than just the money and value of the land that's around us. There's a deeper physical and spiritual connection that we all have to the land as tribal people. So when we think about the roots of democracy and where we got to today for our tribal governance structure, we think about the principles of governance of tribal nations and the influence that our governments have had on the society of the United States. In the 1100s, the Iroquois League of Five Nations, which is formed by the Mohawk, Oneida, Cayuga, and Seneca, and their constitution was referenced by Ben Franklin. And Ben Franklin's proposed the Albany Plan, the initial plan for the US, and it was based upon that Iroquois Confederation. So as we think about that, Ben Franklin studied that document and drafted the US Constitution based on the Iroquois Confederacy. So the principles of governance were influential, of our tribal nations, influential on the US and in the structure of the government today. And as we like to say, we were the people before we the people, as mentioned in the Constitution. Tribal governments are mentioned, and tribal nations are mentioned in the Constitution several times, and we'll touch on that next. But as we think about that, it's really important to understand that and the fight that tribal nations have had in maintaining that impact and the words that are in the Constitution today. Two of the Indian clauses in the Constitution reference Article 1, Section 8, the Commerce Clause, which talks about Congress having the power to lay and collect taxes, duties, imposts, and excises to pay the debts and provide the common defense and general welfare of the United States. So that's all great, but it also mentions to regulate commerce with foreign nations and among the several states and with the Indian tribes. So it's important that we have that specific mention in the Constitution that puts us at that level with foreign nations and several states as well. As we also look at Article 6, Paragraph 2, the Treaty Clause, this is very important, in which it talks about the laws of the United States shall be made in pursuant of all treaties made, and which shall be made under the authority of the United States shall be the supreme law of the land. So again, the importance of the separation of Indian tribes and the treaty clause being the supreme law of the land is going to be important as we progress throughout the future of the interactions with tribal nations with the United States. Many Supreme Court cases reference these sections, and often tribes have legal battles to ensure the upholding of these clauses to this day. So how that affects tribal financial management, we take a look at some of the Indian policy periods as we move forward, and we'll touch briefly on these initial sections. But as we think about colonial status through removal and location, and the reservation and treaty making period, again referencing back that clause of the treaties that were made during this time period, and that it is the supreme law of the land. Looking at allotment and assimilation, so all of these were not good periods for tribal nations, but it built up to the area of Indian self-governance in 1934 through 1953, that really set a period of tribes taking over their own management. Of course, there was the termination era, which was a terrible period for tribes, mine included, which was terminated in the 50s and restored in the 70s, in a time period where there was an attempt to eliminate tribes in general. But it built up the self-determination period, which we get into in 1968 to the present. And the self-determination era is really where tribal financial management came about, where the Indian Self-Determination and Education Assistance Act was passed that was able to provide information and the basis for tribal financial management today. Before we look at more information on the history, we want to touch briefly on the Marshall Trilogy, which are the guiding principles in Indian law that have an impact on Indian law and financial management for governments today. So here, the Marshall Trilogy references Supreme Court cases that were dynamic, controversial. Chief Justice John Marshall established that still governs today. And these three cases are Johnson versus McIntosh, Cherokee Nation versus Georgia, and Worcester versus Georgia. The importance here is in the first case, Johnson versus McIntosh addresses the issue of who owns the land. And this is where the decision was made that the United States owns the land, the reservation, so that trust land, and that Indians are the tenants. The United States holds that land into trust for the tribes or the tribal citizens. The Cherokee Nation versus Georgia, the issue at hand is, what is an Indian nation? Is it a foreign nation? Is it a sovereign nation? And this is where the trust relationship was established. So tribes are under the protection of the federal government. They cannot claim political independence. And we'll talk a little bit more about sovereignty and sovereign immunity in the next slide and how that impacts tribes today. And then Worcester versus Georgia, the issue of competing sovereignty, states versus tribes, and who will control the westward expansion. Here, this decision affirmed the Indian self-government and the Indian self-government over the states, and affirmed that treaty rights are binding. So again, going back to those clauses in the Constitution that the treaties are the supreme law of the land, and the separation from Indian tribes versus states and foreign nations. So very important decisions here. Obviously, just touching the surface of each of these, and I would encourage everyone in attendance to do some additional research on this, because this is important and has a large impact on how things move forward today. What's interesting, even though the Supreme Court established each of these cases and the decision was made, that doesn't mean that other branches of government follow that. And that was the case in Worcester versus Georgia, in which President Jackson at the time refused to enforce the decision and pass the Indian Removal Act. So even within the United States branches of government, there's issues that arise that tribes have to manage throughout as well. So next we have to think about sovereignty versus sovereign immunity and the difference between the two. So sovereignty, governments have the right to regulate their own affairs within a geographic area, and federally recognized Indian tribes retain their original sovereignty within reservation lands to the extent not expressly limited by acts of Congress or their own voluntary waivers. Sovereign immunity, however, is a legal doctrine that prevents lawsuits against government entities. And the theory behind that is that those public rights outweigh private rights. And so there's a waiver that is available, that sovereign immunity can be waived by statute or clear and unequivocal intent, narrowly construed. So for tribal governments, finance, oftentimes bank agreements will ask to waive sovereign immunity. Not all of the tribe's processes are the same on how this process works. And so it is important to read and review the tribal constitution and laws governing the tribe on how this works and how limited waivers of sovereign immunity are provided. Examples of this include, there was a broadband grant companies asked for tribes to waive sovereign immunity via resolution. The American Rescue Plan Act, when it was first released, slipped a fast one on tribes, I think, and asked tribes to waive sovereign immunity to accept the ARPA funds. That was addressed by many tribes, and that was later, that requirement was later waived for tribes. The other example to consider here is looking at things such as tribal limited liability corporations versus state limited liability corporations. So tribes have the ability to govern their own affairs and create their own laws, and in doing so can create a tribal limited liability code in which sovereign immunity is not automatically waived. Whereas oftentimes if a tribe creates an enterprise under a state LLC, they lose their sovereign immunity. So in all cases, I think tribes always want to try and maintain as much as possible sovereign immunity. However, as we work outside of tribal nations, there's oftentimes a need to provide a limited waiver of sovereign immunity as it comes to financial matters specifically. So as we jump back into our tribal financial management timeline, we take a look at the 1960s, the self-determination period. 1962, Native Americans were given the right to vote. So interesting here that up to this point to 1962, while there was the supreme law of the land with treaties and the interaction of sovereignty there, tribal citizens were not able to voice their concerns at the ballot box. In 1968, the Indian Civil Rights Act was passed. In 71, the Alaska Native Claims Settlement Act, and in the 1970s, tribal participation in federal programs that are responsive to the local needs really started. And this created the discussion and basis behind the Indian Education Act, which was later the Self-Determination and Education Assistance Act, which really set up the self-determination period and had a major impact on tribal finance. So this really set tribes up for how to govern and fund themselves and created the availability of economic development. So as we look at this overall timeline and we think about the 60s and 70s, there was a lot of upheaval. This is when AIM, the American Indian Movement, happened for tribes, and there was a takeover of the BIA building and created the discussion to have an impact on where the funding happened, where the funding was going to be provided that is responsive to the local needs. And as we'll later talk about the number of tribes across the country, each is unique and different. And so being able to manage those federal dollars to address local needs is extremely important, because each tribe has the ability to determine those local needs that are beyond anything that the Bureau of Indian Affairs would ever be able to do from a central office in DC. And so here you can see major differences in the work we have to do under BIA versus self-governance. And thinking about prior to this time period and where we are today, that the majority, if not all, of the BIA employees were non-tribal. And so today, most BIA employees are tribal. And so they have a better understanding of our local needs and how that impacts tribes in general at the local level. As we move into the 80s and 2000s, the 1980s is really getting banks to lend to tribes, and access to capital was an issue here. Getting an understanding of where what tribes are considered, right? Are they a government? Are they enterprise? There were enterprises that were managed by the government. The issue of trust land and not having the collateral when it comes to trust land. So all of those issues created access to capital and getting banks to lend to tribes. In 1988, the IRA was passed, and this came from gaming enterprises to make sure that there were gaming commissions. So the Indian Regulatory Act really provided that basis for the expansion of gaming enterprises and making sure that they were regulated appropriately. The 1990s created the foundation for economic development for tribes, and this really was the implementing of accounting for all of these things that were happening during this time period. And as we move forward, looking at the creation of economic development enterprises, the gaming, and how that impacts tribal governments today. In 1996, the Single Audit Act was passed, and this created the need for an audit for anyone who had over an official number of grants had to be audited. And the threshold for that today is $750,000 in grant funding from the federal government that is spent. So the important distinction there is that those funds are spent. You can get more than that, but if you are conscious of how the spending is and you have a spending level under $750,000, you can avoid that audit. However, the Single Audit Act is a good thing in that it is helps strengthen weaknesses and help us be better about our processes internally as we manage these federal dollars and tribal dollars as they expand beyond that. It really helps with internal controls and making sure that we're being good stewards of the money at the tribal level as well. In 1996, the GASB and FASB definition of a government was identified, and tribes were included as government. So again, as we think about previous to this and the access to capital issues and other things here, tribal governments were not included in some of these definitions. And so it wasn't clear whether tribes were governments, whether they were enterprises, whether they're a mixture of both. But here in 1996, it is important to note that tribes being defined as a government, and the language having a unique blend of owning businesses, but also being a government in general. And so it identifies the need to follow the GASB rules and regulations there. In 1998, the GASAC, the Governmental Accounting Standards Advisory Council, which is the entity that makes up the accounting rules in America, created a board-appointed seat on their advisory board. And so that was important, again, as we think about the unique aspects of tribal governments, to have a specific seat so that there is a voice at the table when these government accounting standards are put in place from tribes, to be able to provide input on unique aspects that tribal governments and tribal enterprises face today. In 1999, President Clinton issued Executive Order 13175, which required the consultation and coordination with tribes. And this has been extremely important for tribal governments to be able to provide their voice with any federal action that was going to impact tribes in general. And here, consultations, as an example, consultations with the Interior and Treasury were provided as CARES and the ARPA funding was rolled out. And it was extremely evident that was taken into consideration during the ARPA final rule process, because in the final rule, it specifically mentions all of the comments and consultation, both verbal and written comments that were received during those consultations, and how those were addressed within that final rule. So anytime there's a consultation that is available for tribes, we always encourage tribes to provide either verbal and or written comments during consultations, to make sure that your voice is heard, and that any concerns that you may have with any proposed rules or regulations are considered as they're rolled out, and will impact tribes moving forward. Another big point during the Obama administration in 2014, the OMB Uniform Guidance was released. And this really created a basis around grant management reforms to hopefully make the process easier for tribes. So this created one standard document for grant management. The Uniform Guidance combined guidance that was previously contained in 8 different OMB circulars, including A110, A21, and A133. And so each of those circulars, which created different rules and regulations, now were combined into one document to make to make grant management a bit easier on tribes and other governments and entities that receive federal dollars. So as we think about the governance and the rules and regulations that we have to follow, we take a look at the cascading rules that tribes have to follow when it comes to federal dollars. So of course, as we talked about earlier, the supreme law that has established the United States is the Constitution of the United States. So anything that is released, any federal dollars and any rules and regulations that are in place obviously cannot violate the Constitution. Second, are federal statutes, which are laws passed by Congress and signed into law. And a recent example of this is the American Rescue Plan Act, the ARPA funding. So once that law was passed, the legislation that was and rules included in that become a federal statute that have to be followed. Next, we have federal regulations. These are the rules published in the Federal Register. And following along with the example, the American Rescue Plan Act, this would include the 437-page final rule document on how we implement that law. And so providing that further guidance on how that implementation takes place. Next, we take a look at tribal laws and regulations. So these are the laws and regulations enacted and approved by the tribal government. And as we look at each of these, moving from 1 down through 9 here, the numbering is off on this slide, so I apologize. But as we look at each of these, you can get stricter as you move down, but you you cannot ease up any of the laws moving forward. So as we think about the tribal laws, for example, as it relates to the American Rescue Plan Act in the final rule, we can put more strict restrictions on those dollars, but we cannot make less restrictions than what are listed in the Federal Register of the final rule or in the law that was passed through federal statute. 5, state and local governments laws and regulations where applicable in tribal environments then apply. 6, we have executive orders. So these are directives issued by federal agencies and department heads that enforce or with the force and effect of the law. So here, an example to this related to some of the ARPA funding was Secretary Brian Newland issued exemptions for the BIA HIP program regarding eligibility. And so as some of these executive orders are issued, whether by the agencies or by the president through executive order, they have to be considered as it impacts federal dollars as well. Number 7 are the OMB policies. So this is the instructions to federal agencies on implementing the laws and regulations. And this goes back to that the OMB uniform guidance that is released. Number 8, agency specific guidance. So the program specific guidance that is non-binding but explains how to interpret some of the regulations. And then the last is the federal award documentation. So the terms and conditions contained within the federal award that are similar to contract clauses and contain legally binding agreements. So as you can see, this makes the tribal financial management, specifically federal grant dollars, very, very difficult, unfortunately, because of all of the cascading rules and regulations that have to be followed. So as the implementation of any federal dollars received by the tribe moves forward, you have to consider the federal award documentation and the agency specific, the OMB guidance, if there are any executive orders that impact that, state and local government laws, if applicable in the instance of any tribal interaction, definitely tribal laws and regulations, the federal regulations, statutes, and the Constitution. So making sure we have proper grant compliance and federal tribal financial management in place is important so that we're taking all of this into consideration when we're looking at grants and cooperative agreements with the federal government. So as we think about tribal financial management and some of the unique aspects of tribal governments, we have to understand that tribal governments are sovereign, domestic, dependent nations. So they do determine their own form of government. They define their citizenship and membership in their tribe, and each tribe can be different here. They administer justice and enforce laws. They have the ability to tax their tribal members. They can regulate the domestic relations of its members. So an example here is marriage licenses can be issued by tribal governments as well. They regulate the property use. They are not generally subject to the laws of states or local jurisdictions. So again, that is something that as we look at any of these unique aspects, you have to look individually at each tribe, their constitution, and their relationships with state and local governments. Federal laws that apply to state and local governments generally do not apply to tribes. Again, going back to the Constitution and the distinction between tribes and states and foreign nations. Depending on the business structure, most revenues are not subject to state or federal taxes. Generally, reservation land is not considered an asset. So again, going back to the access to capital issues, there's such a unique aspect to tribes when it comes to reservation land, as it is held in trust by the federal government and not considered an asset. So it is not something that can be used for collateral. It is not something that is put on tribes' balance sheets. Governments receive some exemptions from the OMB uniform guidance, such as publishing financial information to the public. So single audits do have to be uploaded to the federal clearinghouse. However, information is not some of that information is not published financially due to the tribe's tribal enterprises and the risk that it could take on competition and proprietary information that may be included in some of that information. Tribes are generally left out of the IRS tax code, so no tax exempt donations, adoption tax credits, limited tax incentives. They are not written into bankruptcy laws either. Though there has been some recent legal actions that have, I believe, has impacted the bankruptcy situation as well. Tribal leadership has the added responsibility of preserving culture and language. So we talked about this a little bit earlier, as we have a distinction between local and state governments. And so tribal leadership really has to take into consideration all of the things that local and state governments do, with the additional responsibility of preserving that culture and language and being specific members of those tribes as well. So that can really change the dynamic of how tribal financial management and the resources that tribes have available, the decisions that are made in deploying those resources. As we think about tribal governments today, the tribal constitution impacts how they govern internally, how they work with the US government. Again, each is unique. So some have 3 branches of government, some provide decision-making power to the general council. IRA constitutions often impact tribal economic development in the fact that there's a lack of separation of power and provide all decision-making to the tribal council. The secretarial election provisions require changes to the Constitution be approved by the BIA. So again, that BIA oversight is in some tribal constitutions currently, which can cause issues, especially with the need for such a high threshold of participation in elections, that constitutional amendments are very difficult to get passed. Codes and governing documents are unique to each tribe. So here, it's important as you work internally within your own tribe or with tribal governments to really have a thorough understanding of the codes and governing documents within each tribe that you work with, because each can be different, each are unique, and having that understanding is going to provide a better interaction in relationship when it comes to tribal financial management. Tribal governments today, as we take a look at the map of the US based on BIA regions here, there are 574 federally recognized tribal governments, 229 tribes in Alaska, and 344 tribes in 33 other states. So you can see spread out across the US in Alaska, and there's such a unique aspect to each individual tribe. Again, I cannot stress the fact that there are things at the US level that govern tribal governments and the interaction between the US government and the tribes, but each tribe individually has the ability to govern themselves and the uniqueness of that. And so that's 574 separate tribal governments and the unique aspects that they have individually within each. A little information to give you a concept of, to give you some context of Indian country. Today, 100 million acres of total landmass are under the control of American Indian or Alaska Natives. This would make Indian country the 4th largest state in the United States. The Navajo Nation would be the 42nd largest state in the Union, the land base that they have. 19 tribal nations are each larger than the state of Rhode Island, and 12 tribal nations have a land base larger than the state of Delaware. So again, something to think about as we take a look at Indian country as a whole and the impact that it has across the US and the land base that it holds in general. Some other unofficial information, facts here. Each of the 574 federally recognized and 63 state recognized tribes have their own unique language, culture, and traditions. While most Native Americans remain connected to their communities, approximately 75% live in urban and suburban areas. Contrary to stereotypes, Native Americans are required to pay federal taxes like other Americans. Of the 574 federally recognized tribes, approximately 39% have casinos and only 8% of the total Native population profits from gaming. 1 in 3 Native Americans live in poverty with a median income of $23,000. There is a lack of affordable housing, which means people often live in overcrowded situations. And this was amplified during COVID-19, in which health inequities in tribal communities was very apparent due to some of these situations, such as the lack of running water, electricity, living multi-generations living under one household. And so this was also important to consider as the American Rescue Plan Act and CARES Act fund was deployed across across Indian country. So as you can see with each of these, all of this are things that tribal leadership have to take into consideration when managing tribal dollars and being good stewards of the funds that tribes have access to and the availability to, whether that is federal dollars, other grant dollars through states or local governments or other funding agencies, as well as the funds that are generated by enterprises. Tribal leadership has the responsibility of taking care of their membership, making sure that they have the means for living, as well as managing that language and culture. So as we think about all of that information, what are the goals and outcomes of tribal government financial management? So as we look at the goals of tribal government financial management, the goal is to grow the tribal economy to ensure that the essential government functions are carried out in perpetuity. We want to make sure we're providing relevant information to citizens that allow greater accountability by the tribe, enhancing understandability and usefulness to users of financial statements, and making sure financial statements are informed with economic, social, and political decisions for tribal leadership, executives, federal agencies, and other grantors, lenders, investors, creditors, and tribal members and tribal citizens. The funding of the tribal government looks different than state and local governments. State and local governments rely primarily on property tax and sales tax. And while tribal governments can tax their tribal members, oftentimes that is not a significant revenue source. And so tribal governments really focus on federal funding and enterprises that are owned by the tribal government that transfer dollars back to the tribal government for operation. So as we think about how tribes operate, our governmental financial reporting model is more complicated to prepare. Governmental activities are generally funded through the tribe's enterprises, grants, contracts. Business type activities are funded by fees charged to external parties for goods and services. And then fiduciary activities are those resources that at a tribe that are not available to fund government programs, such as minors, trust funds, or pensions, and are funded by business type activities. So as we think about all of that and the overall operations, we have a more complicated view to think about when it comes to tribal financial management. When we look at funding for the tribal government and the impact that it has on financial reporting, we have to consider different rules and government and accounting standards. And so federal funding and tribal governments as defined as a government have to follow the GASB rules, the Governmental Accounting Standards Board, whereas enterprises typically follow the Financial Accounting Standards Board. However, as you look at this, because tribal governments own the enterprises, they do have to either receive an audit finding or transfer those statements, those financial reporting statements from FASB into the GASB accounting standards. which again makes things more complicated when it comes to tribal financial management. The difference between the two, GASB versus the FASB financial statements, the governmental financial statements have a statement of net position, statement of activities, and the net position. Whereas under FASB, it's the more traditional business-like financial statements that include the balance sheet, income statement, the statement of cash flows, and the equity of ownership. So again, as you can see with the four different statements there, they do have to be transferred into the three statements under GASB if the accounting standards are being followed by enterprises that are different than the GASB standards. Here's just a quick look of a GASB example versus a FASB example. And as you can see, the income statement versus the statement of activities, the governmental accounting standards is significantly different and more complicated. And so as you can imagine, being able to transfer that information or keep multiple books makes things much more difficult for tribal enterprises and the tribal leadership on the government side as it looks at auditing requirements when it comes to our financial reporting and financial statements. Speaking of auditing, when is an audit required for a tribe? So as we're thinking about all of this tribal financial management and what all of this means, an important aspect of all of this and the need for such stringent control of our financial management is to ensure that we can be audited in a clean manner. Audit is required when a tribe's constitution or other organizing document requires it. If a tribe receives more than $750,000 in federal awards, we talked about that earlier, that the single audit is required. If NIGC requires it for licensed gaming properties, if a tribe's lending agreements or SEC financing requirements, if a tribe's contact with the state requires it, if a tribe has an entity such as a telecom entity and the FCC requires it, and then there are other special audits for specific procedures such as a revenue allocation plan or a pension plan. So as you can see, all of these things again need to be taken into consideration with tribal financial management as we're preparing the financial statements, making sure things are accurate, taking all of this into consideration. In addition, considering any of the audits that may be required as the tribe moves forward with different priorities. So when we think about an audit, how does the audit opinions look? And here we have the different types of audit opinions. The unmodified opinion, in which financial statements as a whole present fairly the financial position. A qualified opinion, except for the effects of a particular matter identified within that audit. Financial statements present fairly the financial position, results of operations and cash flows. An adverse opinion indicates the financial statements do not present fairly the financial position, and a disclaimer of opinion is an instance in which an auditor does not express a specific opinion. And unique to tribes, there's a dual audit opinion, and this goes back to the need to issue both a GASB and a FASB opinion if the government is following GASB and enterprises may be following the FASB. Here, an auditor will issue an adverse opinion on the generally accepted accounting principles under GASB financials, and a clean opinion on the compliance with FASB. So again, in this instance, an enterprise may either choose to convert their financial statements to GASB or manage two separate books and take a dual audit opinion in this instance. So here, audit opinions are important because it ensures that the accounting functions have accurate information, internal control systems or business practices are in place, or whether they need improvement, whether financial statements are a reasonable depiction of the financial condition of the tribe, and whether the tribe is compliant with required laws or applicable regulations. The one piece to mention here, however, is that an audit does not catch fraud, abuse, or waste. And so that is important to note because oftentimes, especially when it comes to relaying information to tribal membership, and there are concerns about things such as fraud, abuse, or waste, or rumors, it is important to note that audits happen on an annual basis for the majority of tribes, whether that's in single audit or other types of audits, as we discussed previously. But the purpose of an audit is not to catch fraud, abuse, or waste. And so that is why it is important to make sure that those internal controls and business practices are in place and are identified in an auditor's opinion, and things are presented fairly for the financial position of the tribe. So that is today's presentation on the introduction to tribal financial management. Quick note that this information is for educational purposes. So certainly any information here that you would like to dig into a little bit further, we do recommend reviewing your respective tribe's financial policies and procedures, constitution, governing documents, ordinances, federal guidance, all of that in order to address any specific questions you might have. As we conclude as well, if there are any questions, we do have about 10 minutes left that we can take any questions either here during the webinar, or we can take questions via email as well. All right, so it looks like we do not have any questions. So as Jenna mentioned earlier, we will be sending a recording of the webinar as well as a copy of the slides. So as you get those, again, if you have any questions, if you need any assistance, please reach out and we will address those questions or any help that we can provide moving forward.